Paragraph D, the trial court's consideration of the merits of the case. Paragraph 58. Plea and sentence agreements negotiations have been entered into between the prosecution and the defense, and the following considerations were taken into account. 58.1, the nature of the crime. 58.2, the prevalence of these type of crimes in the region of Honorable Court. 58.3, the circumstances relating to the crime. 58.4, the interests of society has also been taken into account. And these factors have been discussed at length between the prosecution, the investigating officer, and the representative of the complainant. 58.5, the state has consulted with the complainant and his duly authorized representative and afforded them the opportunity to make representations regarding the contents of this agreement. 59, the state has consulted with the investigating officer charged with the investigation of this matter, Senior Investigator Bellichan. 60. The accused and the prosecution are in agreement that the accused are guilty of the charges put to them and request that this court accordingly find the accused guilty in terms of this plea. 61. The court has considered all the facts set out and above and is satisfied with the plea agreement and that the accused admitted all the facts and elements of the crime with which they are charged and that they are in fact guilty as set out above. 62. The parties have complied with all the requirements of the Criminal Procedure Act 51 of 1977 as provided for in section 105A and is placed on record by this agreement. May I continue with the paragraph E, mitigating factors considered. The facts set out below are common course between the prosecution and the accused in mitigation of sentence. 64. Accused number 1 is a 50-year-old male. This is of importance since this offense was committed in 2024. Accused number 1 was 48 years of age at the time. 65. Accused number 1 has been married for 2 years and has 9 children, though not in the current marriage, but which he actively supports. The children are aged between 5 and 21 years old and are reliant upon accused number 1 for support. 66. Accused number 1 has fully cooperated with the authorities over a period of time, and accused number 1 has agreed to depose to this affidavit and to give evidence as a state witness in a criminal trial that will follow, and to fully and unconditionally cooperate with the state in relation to the prosecution thereof. He has assisted the authorities in providing insight and context into the commission of the offenses that the accused has been charged with. In addition, accused number 1 has been instrumental in providing insight into the involvement of SAPS officials who facilitated the commission of the above-mentioned offenses. 67. Accused number 1 has pleaded guilty and shoulders the blame for his conduct. He has illustrated remorse by pleading guilty and acknowledges that ultimately the offenses committed have been detrimental to society. 68. Accused number 1 has not wasted the court's time by going through a protracted trial. 69. Accused number 1 has been incarcerated since the 25th of March 2026 in this matter. F. Aggravating factors considered. The offenses are extremely serious and prevalent in the court's jurisdiction and involve a total amount of 228,665,280 rands. 71. Medicaid Swane received the amount of 50,310,590.68, which was under the control of accused number 1 and to the actual prejudice of the SAPS. 72. Accused number 1 and 2 benefited in the aforementioned amounts. 73. The crimes were premeditated, planned, and executed over a period of time. 74. The offense of money laundering has become prevalent and extremely difficult to detect. 75. The effects of large-scale tender fraud of state funds are, to name a few. 75.1. The state is unable to procure resources such as equipment, vehicles, and other tools necessary to combat crime. 75.2. Increased taxes to subsidize failed projects. 75.3. Closure of private companies as potential service providers don't receive any government work. 75.4. Unemployment due to government not being able to fund new projects. 75.5. The SAPS failed to fulfill its constitutional mandate to detect, deter, and prevent crime and ultimately create a safe South Africa. G. Substantial and compelling circumstances as per the applicable legislative provisions, Part 2 of Schedule 2 of 51 of Section 51(2) of the Criminal Law Amendment Act 105 of 1977. 76. The parties agree that substantial and compelling circumstances exist that justify the departure from the prescribed minimum sentences in that. 77. Accused number 1 took the court into his confidence. Do not waste any time in noting a frivolous defense accepted responsibility for his actions, and demonstrated response. 78. Accused number 1 has assisted and cooperated with law enforcement agencies in the investigations of multiple high-profile, high-level corruption matters as follows. 78.1. Accused number 1 has provided a draft statement in which he disclosed the involvement of several high-profile people involved in the matter and other matters. 78.2. The state would have had difficulty in uncovering their involvement and the extent of corruption within the SAPS without accused number 1's disclosure. 78.2. His cooperation has been invaluable to detect and prosecute additional corrupt activities. 78.4. The accused disclosed information of systemic corruption affecting public institutions. 79. The state has confirmed the veracity of some of the information provided by accused number 1, which appears to be reliable. 80. The accused has made himself available as a witness to describe his role and that of others in the contract concluded between Medicaid Tswana and the SAPS. The sentence agreed upon between the prosecution and the accused. The parties have agreed that in terms of Section 105A of the Act, that a just sentence will be the following. Accused number 1, that the court deviates from the minimum sentence as authorized in Annexure A, the certificate provided by the Advocate Johnson. 83. The court, acting in terms of Section 280 of the Criminal Procedure Act 51 of 1977, has taken the offences in counts 1 to 7 together and to run concurrently for purposes of the sentence. 84. That the court, in terms of Section 297 of the Criminal Procedure Act 51 of 1977, imposes a sentence of 15 years direct imprisonment, of which 7 years imprisonment is suspended for 5 years. The sentence date is calculated from the date of sentence subject to the following conditions. 84.1. That the accused at any time upon the request of the state will depose to a statement or statements under oath and testifies at all future criminal matters in which accused number 1 is implicated directly or indirectly or as a director of accused 2 and or 3. And that 84.2. Accused number 1 testifies frankly and honestly without withholding any testimony